Say hi.
Welcome to Things You Need to Know with your host, Sharon Douglas. In today's program, we'll be discussing the U.S. Department of Transportation's Interim Final Rule, 90 FR 47969, introducing important changes to the Federal Disadvantaged Business Enterprise (DBE) program and how these updates could impact your company. Please note, this session is designed for informational and educational purposes only and should not be considered legal advice. If you have questions during the discussion, we invite you to post them right here in the YouTube chat. Now, here's your host, Sharon Douglas.
Good afternoon, and welcome to Things You Need to Know. Thank you for being here. We have a much more needed information coming your way. This discussion is going to be powerful. Why? Because we are DBEs and we need answers. I'm going to introduce my guests. My first guest is Angela Berry Roberson, civil rights attorney and founder of ABR Advisory Consultants, LLC. Angela focuses on strategic and advocate advisory. She was also a former senior advisor to the U.S. Department of Transportation. Welcome, Angie. Next, we have Colette Holt, founder of Colette Holt and Associates. Colette is general counsel of the American Contract Compliance Association. Welcome, Colette. Next, Gina Thomas, owner of Linco Strategic Partners, LLC. Gina presents XBE Certification Authority. Also, Gina was the prior former director of North and South Central certification agencies. Welcome, Sheena.
Hello, thank you.
Ladies, let's get this show rolling. My first question goes out to Colette. Colette, please tell us what the hell is going on. Where are we today? We're DBEs and we're lost. We're waiting for you to walk us through it. Talk to us, Colette.
I think we lost Colette.
Okay,
I don't know if that's
Angie, until Colette comes back on. Let's move on to you, Angie.
Yes. Yeah.
Okay, what do you think, Angie? What do you think is the next step for DBEs moving forward?
Well, the next step is, first of all, get yourself ready. This is not going to happen overnight. There's been guidance. The first thing, as I always say, read the rule. I always suggest you go directly to the ECFR so you can read the rule in the context of the larger program, because the entire rule was not changed. Just certain sections of the rule were changed. So I would go and read the rule itself and then read the 58 pages, which also offer commentary on the reasons why and things about that. The biggest thing, Colette's back, yay. Um, and the next thing I would tell you to do is also, understand you've got to get this personal narrative, and I know Sheena is going to get a lot more in details about that, but the personal narrative done, as well as the PNW, because right now we are in this reassessment, re-evaluation period, and during this transition period, as you'll hear me say later, the DBE program is actually kind of suspended. And so it's not kind of, it is suspended.
Kind of.
Um, and so that's what we'll start. So I don't know if you want to jump back to Colette. So now we have Colette back and I can finish
I
my,
do. I do.
go ahead.
I do. I
Yes,
do. Thank you so much.
go ahead.
Colette,
Absolutely.
I'm going to repeat myself. What the hell is going on? Talk
And
to us. Walk us through this.
I'm so
Help
sorry
us
about
find our way here.
these technical issues. So, well, what's going on is the Department of Justice and the Department of Transportation have determined themselves that they believe that the DBE program, as it has been structured for the last 40 years and upheld repeatedly numerous times by federal courts and federal courts of appeal, is now unconstitutional. And so they promulgated this interim final rule. As Angela was saying, the DBE program essentially is suspended now, at least as it relates to what DBEs are going to care about. There's still reporting and other things that recipients have to do. But the two most important things to take away today are that there will be no more DBE goals set on contracts until this whole reevaluation process is completed. And that if you have a current contract, and I know Sharon may want to talk about this a little bit, if you have a current contract and it's signed, well, you should be fine. If somebody kicks you off of this project because you're no longer a DBE, well, that they may be exposing themselves to some civil rights liability. But there are otherwise no contract goals going forward. New solicitations cannot have contract goals in them, and recipients cannot enforce the DBE program requirements. The other thing to know is that all DBEs, and if you are already in the process of applying or whatever, this applies to you too, but all DBEs are now going to be required to go through a kind of recertification process. And so as of this past Friday, all DBEs were effectively, and ACDBEs, were effectively decertified. So as Angela mentioned, you're going to have to submit a new personal net worth statement, as well as an individual narrative that demonstrates with specific instances the ways in which you have been socially and economically disadvantaged as compared to similarly situated non-disadvantaged individuals. And we can talk perhaps a little bit later more about the specifics, but suffice it to say that anybody who tells you today that they know what that means, I think is either naive or that really just doesn't know what they're talking about, because we're not sure. There was a process that the Small Business Administration used maybe a year and a half ago or so that came out of a court case in which I was actually involved, where 8A certified firms had to submit a new personal narrative of their disadvantage, but it was to focus on race discrimination. This new rule literally writes discrimination out of the program, and so we're trying to figure out what it might look like to describe your social and economic disadvantage without regard to or reference to or reliance to, they like those three different R words kind of sprinkled all over, race or gender. So, stay tuned about that. I think the unified certification programs around the country are now scrambling to try to figure out what that means. The reg says there are 41,000 certified DBEs. The count I usually get from DOT is closer to 50. But whatever it is, it's tens of thousands of firms that we're talking about. And until that process has been completed for each state unified certification program, no DBE goals can be set on those contracts.
We want Angela, can you hear me?
We
I'm
can't
not
hear
getting
you.
Angie.
I got you. I got you. I got to
There
unmute.
you go.
Sorry. I didn't hear your question, though. What'd you say?
I say, would you like to pick up where you left off?
Um, sure. I think that we were talking about everybody's got to do the personal net worth as well as the personal narrative. As Colette said, SBA did have to go through this process for the 8A, but with certain parameters, I think Sheena's going to go into that. But understand, the key thing is not only to read the rule, but also know the rights. You should know this information better than anyone else because as DBEs, small businesses, and ACDBE concessionaires, you need to know exactly what you need to do as it relates to this evaluation process, but also on your current contracts and on your upcoming contracts. As Colette said, no DBE goals or ACDBE goals will be set on any procurements having to do with any transportation projects or initiatives that receive federal funding. Your local programs operate as right now as they are. Some local programs are in jeopardy, some are not. So you need to go back and look at that on an individual basis. But that, this might influence it, but it is not, it does not have any weight on what to do or not to do. And so, and as again, as Colette said, as far as your contracts, if you have an executed signed contract, that's contract law. That hasn't gotten anything to do with this. So you can say, you hired me to do a service. You didn't hire me to be a DBE. So I am still on the contract to do this work. Now, as it relates to the commitment, this is where it gets a little hairy. So let's say that there was a commitment to utilize you, but you have no executed contract, then there might be, there's no level, because another part of this IFR is that accountability is in question. The feds have said, or the U.S. DOT has said, that the compliance element of the rule is not effective. But here's the thing, that could be on an individual basis. The recipients are who the rule really speaks to. So as it relates to submitting the uniform report, as it relates to items that go to FTA, FHWA, and even FAA, those are no longer required. But if your firms and your contracts, you still have stakeholders, you still have a board, and it's still in the contract. And if you want to continue to collect those reports, you just need to make sure it's clear. You might get pushback, but you just need to make sure it's clear that you have a board, you have a commission, you have somebody you have to report to, and you need to continue the collection of that data. And you want to continue that collection of data because when all this goes through, we need to see how this impacted what was going on. And so I would strongly advise the continued collection of data. Just know that that data is not necessarily required to go to U.S. DOT or any of its operating agencies, so to speak. So, again, commitment without a contract, it's questionable. Contract, executed contract, you are good to go. So you need to understand that. So that's the first part.
Thank you, Angie. Thank you.
Sure.
Thank you so much.
Mm-hmm.
Sheena, let's talk about the United Certification Program. The United Certification Program and the task they have at hand with this mass DBE exit, and how are they going to collaborate and get together and get us reevaluated?
Well, Sharon, that's a really good question. And that's something that I hope the UCPs are coming together to determine now. I hope that they were coming together last week when this rule dropped to figure out what the plan was going to be. It's a huge undertaking. And right now, what I kind of foresee for the UCPs is there's going to be a huge capacity issue. Not only are these certifying agencies responsible for the reassessment of DBEs that are currently or were currently certified, but they also have to take into account the applications that have been submitted that now also need to have personal narratives submitted, in addition to those applications that are sitting on the desks or in the queues of certification officers. So no matter where you are in the evaluation process of an active application, you're going to have to stop and request the personal narrative. So if you take what is currently certified or was currently certified, since everybody is pretty much decertified at this point, if you take that bulk of applications and then you add on what you have to now, what's in your pipeline as far as newly submitted apps and those that are on the desks, you are going to find that there's going to be a huge capacity issue with the ability for them to work through these applications in a timely fashion. On average, most certification agencies have about 2 to 5 certification specialists, and I think you've hit the jackpot if you have 5 or more. And they're trying to maintain the current infrastructure that they have. So that's the first issue, is capacity. If you're not looking at your current staffing force and you're not determining what resources you need as a UCP, you are missing the mark. So you definitely need to do that. In addition to that, now we have to question the evaluation of these personal narratives. And I've been doing this for close to 30 years, and I can probably count on both hands how many applications I have worked where individuals sent a personal narrative. And I come from the world of when we had Appendix E. So if I'm thinking about the certifiers that are in play right now, who have maybe been doing certification for 3 years or less, they may have never come across a personal narrative. So how are these UCPs going to ensure that certifiers are evaluating these narratives consistently across every certification agency within the UCP? If you haven't had any training around the evaluation of personal narratives, this is the time to make sure that your staff gets that training. And if you happen to be leading these departments and you've never reviewed a personal narrative and you don't personally have that training, then this is a time that these UCPs need to lean on either some, third-party subject matter experts, trusted advisors that can come in and provide that level of training for them. And then another issue that I see is just going to be this communication to the DBEs and the ACDBEs. It needs to be consistent across the board. So whatever one agency is doing as far as their outreach and making sure that these applicants understand the process, they know what needs to be in the personal narrative. They understand that if they are, going through the full reassessment, they'll have to submit their personal net worth statement, irrespective if you just submitted one or if you didn't. So these could, again, firms that you just certified in September are under this reassessment now. So they just sent you a completely new application and they have to go through the process of this personal narrative and personal net worth statement. So ensuring that communication around the requirements is going to be important. My advice, stick to what is in the IFR. Don't try to deviate from it and infer what you think it means. It calls out very specifically what they expect for these personal narratives to include. Use that as the basis for any guidance that you may want to provide to applicants. Don't start creating something new. Use the regs to your benefit in this particular situation. But, to answer your question, Sharon, it's going to be an uphill battle. I think if anything, if you want to call it a saving grace, they didn't actually put a deadline in there because I don't think they actually think that any UCPs are going to be able to get this accomplished. So without having a deadline, you're not up against the wall, but this has a significant impact on, of course, as Angie and Colette have stated, goals, compliance for these programs. So ensuring that there is going to be some concerted communication with the internal stakeholders And then making sure that that communication externally is saying exactly what is required of these applicants is going to be key. Ensuring that your specialists, your certification officers are trained in how to review a personal narrative is also going to be key. And making sure that it is consistent across all of the UCP members is going to be incredibly important.
Thank you, Sheena. Now, you answered one question that Lydia had regarding timeline. What is really going on here? Because we are Callisto laughing. What's really going on, ladies? You know, here we are. We're up in the air. We don't know which direction to run in. We don't have a timeline. We don't have the UCP that is really set up to take on these thousands of DBEs that have to be reevaluated. What do you think TxDot is going to do with this?
Well, I don't want to speak for TxDot. I always want to be very clear. They are a client. I work with them, but I am, and I should have said this at the beginning, I am not speaking for anyone but myself. None of my clients, not my Texas clients, not my clients anywhere. This is strictly Colette's comment. So please take them in that vein. I want to go back to something Sheena identified about to help explain what's going on. There isn't just the issue of uniformity within the UCP. There's the issue of uniformity between UCPs, because this is a federal program, and these regulations are supposed to be applied regardless of who is actually performing the certification function. So one thing that I'm afraid may happen is that you're going to get wildly differing approaches to this between UCPs. And so I think that is a real danger, and it's not one that any of the UCPs themselves can control, because they're not going to be able to tell another UCP what to do. There is no guidance from U.S. DOT, not so far. I don't know when we'll get any. I don't know what it will say. I mean, who knows how long the federal government will be shut down. I don't think it's any coincidence, quite frankly, that this rule dropped just as the federal government was shutting down. So I don't expect to get any help from U.S. DOT anytime in the immediate future. My own view about what's going on is that this is basically an attempt to dismantle the DBE program. And one of the things that people do need to know, if you do not already, is that there is a pending lawsuit that was filed in Kentucky. It's going on 2 years ago now, really. That was a challenge to the DBE program that was brought by two small non-DBE subcontractors. One's a milling company and the other's a trucking firm. And the federal court in Kentucky has issued a preliminary injunction against the operation of DBE contract goals on any contract in which these two firms are, quote unquote, interested in bidding. Now, note, of course, that they're subs. They don't really bid to anybody. They quote to primes, but that may be something for a little bit further on if we have time. So there is this pending lawsuit. The Department of Justice and DOT and the plaintiffs jointly filed a proposed consent order. That was filed, I think, on the 25th of May. And so that is still pending in front of the judge in Kentucky. At the same time, a group of DBEs and DBE organizations were granted leave to intervene as party defendants in this case. And so that's hanging out there. So one of the things that is, well, I guess interesting is about the best word I could use, about this whole scenario is that the approach that this interim final rule takes is what they are proposing the judge enter as an order. And so I'm puzzled about why they just didn't wait. They'd be much better off to have the imprimatur of a judicial order than what they have now, which is basically the Department of Justice and the Department of Transportation's idea about what they think the law is supposed to be. Which does bring me to another interesting thing about what's going on, which is how rushed this all is. This is an interim final rule. And to get kind of technical for a minute, but I think it matters. There are very specific requirements in the Federal Administrative Procedures Act about how you can file an interim final rule, because you are circumventing public notice, comment, and input. And my own view is I think it's highly questionable whether or not this rule complies with the Administrative Procedure Act requirements. So one of the things that I'm certainly hoping or anticipating is that there will be lawsuits filed. And I know that there are discussions out there. I've been involved in them and basically talked about nothing else for a week about what possibilities there may be for various plaintiffs and agencies to file for temporary restraining orders as a nationwide class action. So we may get a temporary pause anyway, which if we do, would at least give everybody some time to try to figure out what to do. So back to Sheena's point about training and these narratives, this is a different kind of narrative than we have ever seen before. And so one of the things that I'm deeply concerned about is how people are going to figure this out. What is this going to look like? And what will U.S. DOT ultimately approve? So I'll wind up with this. There is a Trojan horse provision in this rule, and you don't find it until you really read it 2 or 3 times all the way to the end. And there is a sentence in there that says that U.S. DOT can come in and audit any UCP that it wants to. And as we have seen in the last 10 days or so, these type of audits can lead to the freezing of federal funds. People may have seen where the Federal Transit Administration is now freezing $18 billion for New York's Metropolitan Transit Authority, and now $2.1 billion to the Chicago Transit Authority. And as a native Chicagoan, to say we catching it at home, that's a mild understatement. So this is a real problem potentially, which is U.S. DOT could come in and say, no, we don't like the way you've been doing it. And until they get approval, you can't set any more DBE contract goals. So I know one of the things that Sharon wanted to talk about was what DBEs might do now to help them prepare themselves for. And I think somebody else was going to take that one.
Well, let me interject here. First of all, I had a meeting with my staff yesterday. Just by the impact of receiving this letter, I knew that I had to jump into action. Our discussion was on strategic planning. What's next? What do we need to do different as a company? First thing we're going to do is evaluate what are the other opportunities out there. My business is made up of 60% DOT, 40% commercial and other. Now, DBEs around the U.S., you should know by now, there are other opportunities that you can take on. TxDot, for example, does have a maintenance program that you may want to look at. The other thing that we're looking at is other city opportunities, municipalities, and so forth. Put things in your basket that you've never touched, that you never thought of touching. Those are opportunities. What are you doing? You're trying to fill your backlog. You know right now that we are taking a loss. Evaluate that mentally as a loss. Do not expect that this thing is going to work out. Work as though it's not going to work out. Move forward. Don't find yourself in a tunnel. Don't get your vision locked in. Expand. Talk about it. Reach out to other DBEs. Get input. That's my information. That's my advice. Because this thing is real. And we have to move forward.
And
I
I can tell you,
coming on the face.
yeah, and I can tell you, this is very real. Colette spoke a lot about timing. Let's talk about what's really the Trojan horse. And a lot of people have said, okay, what does that do with my existing goals? Well, right now, compliance is not necessarily required. Good faith efforts in that perspective, as well as commitments, doesn't really exist at all as it relates to your DBE. We're only talking DBE federally assisted. So whatever you're doing on the local side, you need to make sure this is not everything. It's just the DBE and your federally assisted projects. Now, some of you are like, that is all my projects. Okay, well, then that's the case. But for those that know, I'm just saying that those are what we're only thing we're talking about here. And so, depending on your relationship with your prime contractor, depending on how the commitment of the prime contractor in doing and working with others of other types, that is all going to be played. The private sector is going to be a really important piece in this path on how they're going to continue to flow. Some understand the business case and that, look, if I'm working in the south side of Chicago, I'm not crazy. I'm using a lot of different types of firms that can do this work. Or I work in Atlanta, or I work in other places. So that's up to individual entities to do that. And remember, I keep saying entities because it's not just highway or DOTs. It's your transit authorities. It's your ports, for those of you guys who have ports. It's anything that falls under the purview and receiving DOT federal money in any case. So, and airports as well. And so, timing is interesting because, again, notice one, right before a government shutdown, all of a sudden, oh, well, so now you can't call anybody because nobody's there because, the government shut down. Then two, we are on the cusp last year and last administration, or a couple of years ago, there's this little thing called the infrastructure bill that's $1.4 trillion worth of work. And so all those monies are being pulled out, except for the ones being held in New York and Chicago. Oops. They are about to hit the street. Okay. And so I would say between now and the next year, there are going to be a significant amount of large projects that are coming out. Until this reevaluation is done, the DBE are suspended. Therefore, even if it gets back to the projects have already been awarded. And again, it's up to those relationships to do so. Now, the other thing that is out there, and a lot of people are like, well, I got to work on what's doing now. What I need everybody who is a DBE, a public entity, everybody else to think about, the DBE is, yes, it is statutory. It is in the Surface Transportation Bill. The Surface Transportation Bill program is up for reauthorization next year. A lot of people are in the process of talking about this but the DBE program is authorized in that particular piece of legislation. If it is not included in the reauthorization, there is no DBE program. Period. I'm just saying. Now, that doesn't happen until next year, but next year is next year. That's 3 months away. I'm just saying it doesn't happen in January. They've been working on it, and it goes until fall of next year. So, but people are already starting. So you need to make sure that you guys don't lose keep your eyes on what's going on. What I always say, follow the money.
Yes.
Follow the money. Big contracts and the program. So that's what I have to say as far as, what do we need to do? Sure. Do the personal narrative. Yes. Do that. I mean, that is your own business decision, whether you determine to do it or not, to try to get, reevaluated and hopefully get the DBE's program. But again, it is a Band-Aid. It is a pause. The big picture is the program in the reauthorization bill.
Great. Thank you, Angie. Let's take some questions. I have a question from Carolyn T. Government contracting rules reviews during proposal and contract award responsibility and responsiveness. Will this be applicable to the UCP process? Sheena?
I'm trying to understand government contracting rules reviews during the proposal. No. No, I think this is more of a compliance question. So I'm going to tee this over to Angela Collette because it really doesn't apply to certification.
I'm not following the question either. If the question is will DBE requirements and goals still apply to the proposal and contract award and responsibility determinations? The answer to that is no. That's what we're trying to explain to everybody, is that there are no DBE goals going forward. And there are no DBE requirements. There's no requirements to make good faith efforts, none of that.
And there's no DBE.
Yeah, so if that's the question, because the UCP process has nothing to do with the determination of the award of any particular solicitation. And maybe we should explain for a second what the UCP process is, because we all know, and we sort of assume people do, but maybe they don't. The Unified Certification Program is a requirement of the DBE program, and all 50 states and the territories in the District of Columbia all have to have a unified program for all of the agencies that receive U.S. DOT money, as Angela was talking about before. So that's called a unified certification program. And so the different entities are part of that. There are a few states where it's just one, and they actually are lucky now. Who knew? But they are, because they only got one place they got to go. But if you're like Illinois, I think we have 5, and I think Texas may have 6. And so they're all kind of all over the place. So that is what we've been talking about when we say the UCP process, is them coming together to decide what they think this is supposed to look like, getting agreement, and having uniform application of it. And as I mentioned before, then we have the additional problem of uniform application between the UCPs. And what will DOT do about that? Because until there's real guidance, and there really isn't any in this reg, I think people should stop kidding themselves about what's in here. I mean, I'm not sure what to do. And so, who knows what US DOT will and will not approve later on, but that's what the UCP process is.
Another question, ladies. How will the individualized narrative of disadvantage be evaluated? What type of documents or examples would carry the most weight?
I think that we've kind of answered that, and Colette just said it. There isn't much guidance. What I can tell you is what's in the IFR is in the IFR. So if you want to refer to anything, that is where you go. Now, it calls out what it expects for this personal narrative to include. However, again, what it actually means, we don't really know, and how that applies to your individual circumstances, I can't tell you that. But the IFR clearly states that the personal narrative has to identify specific instances of economic hardship, identify systemic barriers. It also has to show the denied opportunities and how they impeded the owner's progress or success in education, employment, business, and so on. And then it has to state how and to what extent those impediments cause the owner economic harm, including a full description of the type and magnitude. I am literally reading that to you because what I'm not going to do is infer or guess about what the IFR is saying. So that is my advice to any DBE, ACDBE. Go to the IFR and read it specifically for what it's asking you. If you have never written a personal narrative before, while the SBA's guidance that they put out refers to including, gender as well as race, and we know that you cannot do this under this IFR with this personal narrative, it does, however, give you a good kind of base of how to ask yourself certain questions, making sure you're identifying the how, the when, the where, the why, and to what effect. That can at least give you an idea of how you need to construct your experiences. But, to what magnitude these things are going to be reviewed, I don't know. There isn't a weighted evaluation that has been identified in this IFR. So there aren't going to be like points assessed to how much more disadvantage you had over someone else. But my advice would be to start thinking about your past experiences through education, through employment, business related issues, financing issues. Just start thinking about those, again, irrespective of your gender and your race. You cannot mention it. You can't use it as a basis of the reason for that specific incident that you or instance that you have in your narrative. That is the huge difference between the SBA's guidance for their personal narrative and this IFR. Okay. And again, as Angela and Colette have said, you all need to read all 58 pages of this rule because it clearly lays out the true intent. I mean, they're getting away from, race conscious, race neutral to DBE, neutral, AC. I'm like, I'm so confused with the different acronyms and usage of terms because they really don't make sense. But
they were not meant to make sense.
Question, yeah.
Right. It's not
that's Sharon speaking. They were not meant to make sense.
It's not. It's not made. It's not supposed to work, people.
Right.
I've spent the last week having people call, text, email, asking me, how's this all supposed to work? And to be honest, my answer is, I don't think it is supposed to work. I think it's been very clear where the Trump administration stands on issues of civil rights. And in many ways, this is the premier business civil rights program in the nation and has been. It has always been the gold standard. When I'm writing local programs for folks, I'd hold them up against the DBE regs and I would tell people, you can deviate, but you need to tell me why. And we have, I think, 13 or 14 cases that have upheld these regulations. And so one of the things that's really interesting to me as a lawyer about this is how thin the basis is that all of this is sitting on. What they do is they cite to this pending motion, pending, mind you, in this Kentucky case. And then they cite to Trump's executive orders, which are also in litigation, and they may get struck down. And then they cite to their own memos saying the very thing that they already said. So it is this sort of self-referential conversation now about what Pam Bondi's Justice Department would like the law to be. They also cite to the fair admissions case. That's the Harvard and University of North Carolina undergraduate admissions program case from a couple years ago. However, college admissions is very different than public contracting. And so they just kind of took that and kind of layered it on top, which is to Sheena's point, is one reason you're like, huh? What does this even mean? And so I think that the best advice I can give DBEs, and I'm a tiny little, obviously Black woman-owned firm myself, is this. First, as Sharon mentioned, shore up your relationship with the primes that you already work for if you primarily work as a sub. And that means going and seeing people and sitting down with them and talking with them. If you can move towards trying to do more prime work, I would certainly urge you to do that because their goals wouldn't have made any difference anyway. The next thing I would do would be to take a good, honest, hard look at myself and my own operations. Where am I weak? Where do I need to do better? How can I increase my skill set so that I can be the firm of choice without regard to my having DBE status for a lot of these firms? And then the other thing I would do would be to go to these agencies and say, look, we're going to need more supportive services. Here's what will help us to grow. Here's the ways in which you can improve your own operations, Ms. Agency, using race neutral measures that I've been yelling at people about for 20 years they needed to do. Quick pay, evaluate your risk profiles. Do you really need $10 million worth of commercial general liability insurance to do a $500,000 project? How long are your solicitations out on the street for? Who's on your evaluation committees? There's lots of things that agencies control that they could do better, frankly, to try to help small firms. And so while we no longer have DBE contract goals, and we may never get them back, folks, I wish I could say something different, but I can't pretend that it's some preordained outcome because it's not. So in case we don't ever get them back, what can these agencies do better themselves? Which is not looking at the primes, it's looking at their own operations. And then, talk about small business approaches. And we can talk about that if there's a question about that, Sharon. I don't want to hog this time.
Yeah. I was going to go ahead, and I was just going to say, I think the conversation of small business should not be dismissed. I think it should start to, in this transition period, for agencies. We talked about the DBEs, we talked about the others. The agencies should really, and I know some people have already started with the small business program, and a lot of people have asked, and I'm sorry, I cheated. There's a question about it, about the small business program. But unless it's a USDOT approved small business program, you can't just arbitrarily put your small business goals on these federal projects, unfortunately. So there are some that took, a lot of FTA grantees did do this. I know a couple of states did as well. So that is an option. But in this transition period, yeah, you should really start to shore up a somewhat of a small business program. And then another point of clarification, I think, somebody asked the question about decertified. Firms are not decertified yet. They basically are in the reevaluation process to determine whether they will be decertified, will they be recertified, or there's going to be some kind of curative motion. So right now, you are a DBE, as ineffective as it is right now. But you have to basically go through curative measures in order to meet the new criteria. But again, there's no DBE goals.
Let me say something about decertification, because this is one of the legal weaknesses that I think is potentially in this rule.
Right.
There is a portion there that says that the decertification due process requirements that are in the regs now, if you get decertified, do not apply.
Right.
So let's say you go through this reevaluation process and you get turned down. As far as I can see, you have no appeal on that. This strikes me as a really potentially serious problem here, because certification has been held by some courts to be a property interest that, once conferred, cannot be taken by the government without all of the pieces of due process, substantive due process, as we know it to be. I mean, if there are any lawyers on the, think about like back to first year law school. So if there's no due process here, is this a valid reg? Because you can't have a process that there is no way to appeal it.
Right.
But there is none. It explicitly say it doesn't apply. So it strikes me that is really an issue, because let's say that you only have a 50% through rate. Let's say only 50% of the firms get through this process, whatever it is. Is there no rights of appeal for those folks? Especially if they were already DBE certified.
Yes.
I don't know how this, again, I don't know how this is all supposed to work.
Okay.
And I don't know that the drafters do either.
And
ladies, we have several questions, so let's get to the next question. And you may have already covered this. And the next question is in regards to good faith effort. Personally, I'm going to say there's no longer a good faith effort.
There are no longer good faith efforts.
Gone.
Okay, I hope I answered that question for everyone. The next question, will DOT issue a final rule after this interim version?
Who knows?
And how
Starting
long?
effective.
I'm sorry.
I'm sorry. Go ahead. I apologize.
I know. I feel the same way. I saw the shoulders and everything, and we had no idea. I had no idea, and I read this stuff, 58 pages. Oh my God! My weekend, I didn't even want to discuss it after that point until Monday morning. I started calling you guys. All right. Let's
there is a comment period, though. Let's at least get that straight.
Okay.
There is a 30-day comment period on the interim rule. The reason it's called interim is because it goes into effect immediately upon publication. The usual process under the Administrative Procedures Act is notice, comment, public time. Some of you may remember the rewrite that U.S. DOT just went through last year in May of 2024, and Angela was very, very deeply involved in that when she's in Mr. Secretary Buttigieg's group there. So you do have an opportunity to comment.
Mm-hmm.
And for those that want to do that, I would certainly urge you to do so.
At least it's on the record, but I don't know if that's going to change anything. I don't mean to be,
Yeah.
Yeah, this is a discussion. Okay. So Aaron,
we're so grim.
making sure I heard correctly. There will not be DBE goals on projects moving forward, Eric. There will not be DBE goals moving forward.
During this period of time.
Wait a minute, Eric. They have dropped us into the desert, and the sands are flying, and we can't see anything else until further notice. If I can just give you a visual on that.
Mm.
Attorneys on this line, I hope I didn't step out of line on that.
No.
No.
Okay.
Number 2, did you read the second part?
Oh, let me see.
It says the DBE
The
goals.
DBE goals or
Mhm.
current TxDot contracts are no longer. They're no longer. We don't have goals anymore. We don't have
Well,
percentages on
It's a
contracts.
little bit messy. I
Yeah,
mean, to the
it's
extent
messy.
that
Right.
we're going to pick on Sharon here.
Thank you.
Sharon's company has a contract with prime contractor, Joe, and he is committed to pay her X dollars to perform X scope of work. She
Mhm.
has an enforceable contract that's got nothing to do with the DBE program. Now, what she might have been chosen because she was a DBE and he was trying to meet the goal. He may have gone to the directory and that's how he found her, but she now has an enforceable contract. What we really mean to say is that TxDot won't be able to enforce the DBE rule requirements as against that contractor.
Correct.
But Ms. Douglas will in fact have a contract that she can enforce under regular old contract law principles.
Mhm. And the DBE goal is still there. It's just not enforceable
Exactly.
Yes.
on existing contracts. The goal, I mean, it's contractual, but it's just no longer
And
enforceable.
enforce it, right.
Right.
Okay, here's another question. Will the personal narratives be kept private, confidential, or will they be open to the public record?
They're going to be a part of your certification application as all your other documents would. So yes, they will be confidential. And everything now is electronic, so it's going to be held in this certification management system as it is today.
Okay. Can you guys put the next question up? Sharon, can you repeat the name of the program legislation we should be tracking that will have to reauthorize DBE program next year?
Is that Sharon or me?
You.
Yeah, it's the Surface Transportation Reauthorization Bill. I don't have the link with me, but I'll get that. So Sharon, anybody who registered the call, but I mean, you can just literally
Google it.
Mhm.
Surface Transportation. And honestly, I'm just letting you know, if you are working with, trust me, the prime contractors and the industry, as well as all the agencies, transit, highway, ports, aviation, they're all talking about it. Trust me. They got whole subcommittees for ASHTO and ARPTA and everybody else talking about the reauthorization bill. So trust me, the industry, everyone is talking about, you should be in them conversations so you can make sure you say, what about the DBE program? What about the DBE program? I'm just saying, they're already there.
All right, ladies, here's one from, I'm going to call Stephanie. Ladies, thank you so much for this session. We're in uncharted waters. My hopes, the UCPs would all get together and make the process the same as mentioned. Thank you, Stephanie. Next question. Do you think DOT will adopt SBE requirements across the board for all?
They might.
They might.
I doubt it, but they might. I mean, one thing to think about is that the current, this IFR in some ways is SBE minus, because usually an SBE program would have had the personal net worth requirement. Let us hope, please, people do not put together SBE programs that have no P&W limits. I don't know about other places, but I have looked at Texas, and 99.8% of the firms in Texas will qualify as small. Okay, so if you don't put some other kind of parameters around there, that's everybody in it. So I'd say essentially that's useless. So you would have a personal net worth test. You would have a size restriction. You have both of those now in the IFR, and then you've got this other thing that you're supposed to go off and prove that nobody knows what it means or necessarily how to do it. So a small business approach in some ways will benefit DBEs as against this idea Now, I've always been somebody who was opposed to small business programs because the point of these programs was to combat identified race and sex discrimination. These are civil rights programs. They aren't business development programs. Yeah, I mean, they may have that impact, and that's great. But the idea here was originally to ensure that the descendants of chattel slaves had the ability to get fair opportunities to participate on federally assisted transportation contracts. That's where this came from. By the time you get to small business, you've completely unglued from the underlying objective here, which is to remedy identified discrimination. So I was always opposed to them. Anybody that's known me a long time might be shocked to hear me say, well, what about SBE? Because at least then we wouldn't have this other overlay that we really don't understand what it is or how to do it. So think about that. But you do need to get approval, if you don't have it already, to set SBE contract goals on federally assisted projects. There is no ability to just swap out an SBE goal for a DBE goal. You can do DBE set-asides SBE set-asides under the current regs, but you don't have the authority without approval to set contract goals.
Thank you, ladies. Stephanie, I feel your pain. Can they please make sense, is what she asked. And Shanisha says, of course not. Civil rights are being chipped away. Yes, ma'am, they are. Would age discrimination be considered? That's the next question.
Oh, now that is a really interesting question.
That is a really good one.
It's not race. It's not race or gender. So why not?
I guess, yeah. I mean, why not? I think discrimination on the basis of disability would certainly qualify. And we always thought that's kind of what the Appendix E was about, was white men who were disabled. If you are a military veteran and you can actually point to examples, concrete examples of how being a military veteran impeded your ability to get a loan or get a contract or whatever, use that. Location. If you grew, if you came from an area that was very low income, or sort of out of the mainstream of most capitalist opportunities, that's the kind of thing maybe you could take a look at. Are you the first person in your family to go to college? Now, one kicker about this, though, is that the reg also says you have to compare yourself to similarly situated others. And this is really where my head wants to explode, because I'm not sure how people are supposed to do that on an individual basis. Now, as a disparity study researcher, we can look at large databases and say this group, this group, this group on the basis of race and gender. We have no data to do it on anything else. But as to an individual being able to say that, I think that would be difficult. But if you've got examples, you should use them. Back to some question that was before, I was asking about what weight different types of evidence would get. Certainly to the extent you have documents, I would certainly attach them. If you filed a complaint with somebody, or, you've got anything that would support that, do try to provide documents. But I like this age discrimination idea quite a lot, especially as someone who is now on the other side, anybody who could be called young. I think that might have some legs on it. So thank you for that. I really appreciate whoever that was.
Thank you, Amy. Next question. Gary asked, how in the world can we prove discrimination without saying race?
Well, one of the things that has been stressed before, this IFR is really talking about disadvantage and not discrimination. And so, yeah, discrimination could be a disadvantage, but, going to the disadvantage perspective, I think that's where, how are you disadvantaged, not discriminated against? And so that's the guidepost that you got to look for. What has made you a disadvantaged person, not somebody discriminated against? Now, you can be disadvantaged because you're race, you can't use it. You cannot use race or gender. I mean, you cannot even say I'm a white man. That's why, because that's race and gender. But I would try to stay away from discriminatory perspectives and look toward what makes you disadvantaged, and then go that way.
I mean, and think back to, your elementary school, middle school. I mean, did you happen to go to a school where you all didn't have books? But, the next school district over, they had books and laptops. Maybe you all had to share books. Maybe your school was very rundown. It was in disrepair. You didn't have access to some of the same things that someone else did. And that kind of set this chain of you then not being able to get into, the high school you wanted to, or then not being able to get into the college that you want to. Maybe you made it to college, but hey, you went to a college where all of the professors were underpaid. They were less qualified than other professors. And you didn't get the type of, collegiate experience and education, which then prohibited you from getting the types of jobs that you were applying for. I mean, you have to really think beyond, as Angela said, it's not about your race, it's not about your gender, it's about your circumstance. You have to think about your circumstances. And since this IFR doesn't in particular say that you can't mention, your lack of resources in school, why not mention that? Why not tie all that together as the reason why you have suffered these disadvantages and it has put you in this position, which has, as the IFR has clearly spelled out, it has left impediments that cause you economic harm. I mean, we have to be creative, folks, because again, as we've said, we don't know. We don't have all the answers. It's vague like this for a reason, because they don't expect for you to actually complete it. They don't expect for you to submit it.
Okay, we're going to take one more question. And matter of fact, there are two ladies. Kai, I'm trying to understand what your question is. I will briefly go through. Can you guys post that on the screen, please? Is disadvantage based on sexual orientation qualify for SBE certification? Ladies, can you answer that question?
Well, that's a really good question. I'm not sure, because there is some case law, and there's a Supreme Court case, Clayton versus Bostock, that held that Title VII's prohibition on sex discrimination included discrimination on the basis of sexual orientation and identity. We were all happy when that case came down, but that is a bit of a trap there. So we do have a Supreme Court case that says that sexual orientation is sex. And if that holds, then no, you would not be able to do that. I'm not so sure, though, that you couldn't craft a narrative that doesn't really refer to sex per se exactly. But I think that, well, SBE certification.
Yeah, it does.
Well, SBE certification doesn't matter. Doesn't matter who you are. You just have to be small, and you're going to have to be economically disadvantaged. So not for SBE. I think probably they meant DBE. Maybe Kai. Hi, Kai. I know you.
Hey, Kai.
Okay, now this is coming from Keith. Keith is asking how to get in the fight. How can we assist? How can we find out about potential lawsuits that we can join?
Okay, well, I can talk about that one. To the extent that there are going to be lawsuits filed on behalf of DBEs or DBE organizations, if you are not active in any of them, I would suggest that you do so. Keith, I don't know, what kind of work you do. If you work on airports, call AMAC. If you work on transit agency projects, call COMTO. The National Association of Minority Contractors is another one. There's a new group out there. I don't know much about them, but I know that they exist, called DBEs of America. So get in touch with some of those groups. If you can't find them, you can email me, and I can certainly put you in touch with those folks. As for the lawsuits that might be filed by the entities, by recipients, there really is not a way for you to participate in those. But don't worry about that. The AG will have, they'll be okay. I guess the other thing you can do, of course, is to stay abreast. Pay attention to anything that you get from your certifying agencies. Don't do what so many people do, which is I'll get to that later. And to the extent that we're trying to mess around, I'm working with Justin Talbot Stern from B2G now. We're just kind of messing around with what kind of prompts you might be able to use. Trying to use some of these large language models to help people craft stuff, because one of my fears is TxDot is what, 6,000 DBEs? There's 6,000 certified DBEs in Texas. If I get 6,000 different approaches, there is simply no way on earth that Sheena or Angie or anybody will be able to do that. That is just not humanly possible. So we're going to need to get some kind of standardization going here. And I'm not sure how to do that, but definitely do pay attention, show up at things like this, any opportunity you can get to get educated.
Ladies, if there's anything you would say to our audience in closing. Sheena.
I'm going to say to all of the DBEs, ACDBEs, read the IFR, contact your certification agency and find out what their next step is if they haven't already sent you a mass blast about sending in a personal narrative. And then start determining how you put your personal narrative together, okay? To the UCPs, you need to have a plan in place. You need to ensure that you are going to be able to manage your current capacity, including the new capacity with these reassessments. And, you know, to Colette's point, we don't know what these personal narratives are going to look like, but as much training as you can get to get your staff ready for this, that needs to be your main focuses. Again, don't get outside of the regs. As long as I've been training specialists, I tell them all the time, stay within the regs. When you go outside of it, that's when you get in trouble. As crazy as this one seems, stay within the crazy so that you don't get in trouble, okay? Don't start inferring, don't start creating all these new workarounds and all that good stuff. Stay within the regs, make sure that your specialists are doing so. And same thing to the applicants. The regs are the regs. Ain't much we can do about it right now. Stay within them.
AI is cute, but don't necessarily is not the all be. I mean, you got chat BGG and everything else, but remember those personal narratives need to be narratives following the rule. I mean, you can put it in there and it can spit something out, but if it's not relatable to you with specific instances, or this might have to be an old school way of doing things. You need to do it yourself with either a pen and paper or you can type it. So I that's what I encourage on that side. Also, you know, again, in reading, everybody's going to tell you to read the rule. But understand this is not just about certification. This is definitely about compliance. So, and the lack thereof, better way. And understand that, you know, making sure that you have that executed contract. If you don't throw a fit. Don't be talking about good faith efforts because it's not required. Now, like I said, reporting, it's totally different. Reporting can be on a case by case basis. It's just not required to send them to DC. But if the various entities and the stakeholders need that information, and we do need that information. Documentation is absolutely key on making sure that these programs, and they know the impacts of what is going on with this IFR as it relates to, I mean, report what you need to report. If you're not using them, you're not using them, but report it. And then, again, for those who have, instances and belong to a lot of these industry groups, be a part of that. I'm telling you that everybody's got a subcommittee on the infrastructure reauthorization. Be a part of it. Be knowledgeable. Mm-hmm. Yes, find out about the court cases. Be knowledgeable. The best thing I can do is, this is your livelihood. Stay on top of it. And like I said, groups like AMAC and COMTO and WTS and NAMAC and your various contracting associations, they should be on top of that. If not, demand that. for your membership dollars. Trust me, as a new small business, for your membership dollars, I should get some of that. And so we need to make sure that it happens.
Thank you, Angie.
Mhm.
Colette.
Stay strong. It's a rough time. It just is. And I'll leave you with this. I read something recently that has helped me, because by 10 o'clock every morning, I am screaming and grabbing my husband's arm that we're all going to die. So we must tread the path our ancestors forged for us. And if they could continue to walk forward, so must we.
Yes. Yes, well said. Ladies, thank you so much. I know all of you have busy schedules. Thank you so much for jumping in, for showing us the way. We may not have a complete path, but at least we've heard something to give us more energy to move forward. If you haven't, then call my number. A lot of you guys know me. I'm going to still say my closure is, again, like Colette said, stay strong. Don't fall into a tunnel and you don't come out. There are people you can talk to. Those organizations have been mentioned, so let's move with it. Let's make sure those calls are made. Remember, relationships. I used to hear that all the time. Relationships. Get out there. Don't sit at your desk. And you know, I'm already antsy right now. I've sat here too long. But this is Sharon Douglas, your host. And we look forward to, I'm getting past some information here.
Yeah.
Oh, yes, this is important. If you want more webinars like this, please leave a comment. Oh, well, thank you.
Mhm.
We'll be happy to do them.
Please leave a comment.
happy.
And let me say this. I want to thank Ellipscore Communication for jumping to our request. Angie made a phone call to me,
2 days.
and Ellipscore, she said twice, and Ellipscore made it happen. So we want to say thank you to Ellipscore. We want to say thank you to everyone who joined the call. And if you have questions, please, the chat is still open. Put them there, and I will surely ask the ladies to respond.
Yeah,
Thank
and one of the things, there's a couple people have asked for our contact information. I guess we'll provide it to you, Sharon, if you can, and you can share it.
You can provide it in the chat.
Okay. Oh, the chat's going to be
do that.
open?
Yes.
Okay. You know, I'm IT.
Okay, do that now.
Okay. Hold on. Join the chat.
And again, if you wish to see more of this, and the ladies have already told me that they are willing to come back and present as this thing moves along, or if it doesn't move along.
Yeah, well,
we
I'm
will have each other
in here.
have support.
Yeah.
You can find me on the web. I'm easy enough on LinkedIn,
Yeah.
whatever. And somebody Keith written. Oh, thanks, Keith. Let's do this every 2 weeks. Well, maybe. Listen, I hope I have something to tell people.
Wait, ladies, let's pick up that energy. Let's keep it going.
Yeah, sure. Why not?
Right now, you know, what can we say? We have an administration that do not see us worthy.
No.
Yeah.
That's coming from Sharon. I'm going to claim it.
Yeah. And Sharon, I'm having a hard time because, you know, I'm IT challenged. Can I use that in my personal narrative? I'm just kidding. I just want to make sure if you can definitely provide that because it's asking me to go through a whole bunch of changes.
Yeah, you got to go to YouTube and sign in and all that other stuff.
Yeah.
So
Yeah,
We will for the YouTube link that we sent out. I'm sure Ellipscore would help us make sure that your contact information is out there.
Thank you.
Ladies,
Thank you very
again,
much.
thank you.
thank you, everybody.
Thank you, Sharon.
Thank you.
Stay
Have
strong.
a great rest of your afternoon.
All right. Thanks. You too.
Yes, sir.
Bye-bye.
Y'all take care.
Bye.
Bye-bye.